Is respected Toronto lawyer and longtime Toronto Star columnist Bob Aaron. Mr. Aaron will be discussing existing wills and how they may not be adequate. He will also explain what is necessary today with the current CRA regulations and how even people with the best intentions can leave a storm behind. And when it does, a will has to be revised. Joining Mr. Aaron is Barry Lebow, realtor, senior real estate specialist, and author. As a featured real estate columnist, Barry's articles circulate across Canada and around the world. Barry is a RE/MAX Hall of Fame winner and is the proud founder of the accredited senior agent designation for Canadian realtors. He serves as a board member on 3 high-rise not-for-profit housing projects for a leading Canadian charity and on various other boards, both in the private and public sector. Barry is also the official realtor for the Reuben Sipin Healthy Living Community here at 2 Neptune Drive. Bob and Barry, take it away.
Thank you so much, Lori. For those that are joining us, and I see there's 30 people, well, that includes Bob, me, and you, so there's 27 people joining us. What I'm going to do is I'll be moderator. I'm going to be questioning Bob, and if I miss anything, of course, that'll come up in your questions and answers. But Bob and I have discussed this many times over the years, wills and trusts, and it fascinates me, wills and estates, because Bob, let me lead off with this. When I created the Accredited Senior Agent Program, it took me a year of writing to get the material together. I went to Canada Trust and Royal RBC and other places, and I kept saying to them, I understand that 50% of Canadians don't have wills. And they said, you're optimistic. Bob, why do so many people just refuse to have a will?
I think, Barry, that people have difficulty facing their mortality. And I had a wonderful client just recently die, no family, no next of kin, and no will, although I was his power of attorney, but he never got around to making a will. And it's unfortunate, but I guess people say, well, I'll put it off till I'm sick, or I'll put it off until I'm ready to face my mortality, or I'll put it off for some other reason. Just wait until that golden goose comes in, or whatever. And whenever I do a real estate transaction, I remind the clients at the end, look, now you have a house. Do you have a will? And most of them don't reply. Or if they say, a few of them will say, yes, I have a will, but of the rest, they never respond. So it's a lot of work making a will, because you have to first figure out where everything's going to go, what you have, and who's going to look after it. And that's very difficult. And so it's procrastination and it's facing mortality. And that's why people are sometimes reluctant to have wills.
Yeah, and of course, you know, you never know. You could be walking down the street and a cement truck hits you. This is the way life is, which actually happened to a client of mine this year. She was standing on a street, and a cement truck went up the curb and hit her. No will. So it's fascinating. So I guess the same type of people are afraid of having life insurance too, but that's another story. The thing is that, what do you think some of the misconceptions are about a will? Like, just the general misconceptions when they're thinking about it.
I think the biggest misconception, Barry, is that people think that that the government is going to take everything if they don't have a will. It's all going to go to the government. And the response to that is, yeah, the government will take everything, but they won't keep it. They'll just hold it in trust forever and ever until somebody comes along, and it could be 1, 2, 3 generations down the line. Yes,
really, that I didn't know. Now I've learned something.
Well, who knows? Who knows?
Wow. So you mean all those ads where I see the government's posting anybody claims against the estate of, So I should start being Mr. Wong, Mr. Kwan, and Mr. Singh and go after the estates?
Well, this is the government holding the money. It's like the money
Oh,
in my trust account and somebody doesn't claim it for years and years and years.
I
What do I
thought
do with it?
it reverts to the queen though, right?
Well, the queen doesn't want it.
You-
Queen doesn't need it.
no, she doesn't. She doesn't. But
But we're talking about the queen in right of the province of Ontario, and Doug Ford doesn't need it either.
just so people understand this, if you die without a will, intestate,
Yep.
you die in this intestate, then
Yep.
the public trustee takes over. And you and I both have had our experiences with a public trustee. I had two at 2 Neptune where the public trustee was involved. Bob, it took them a year to straighten it out and let us have we put an offer in, a year till they accepted the offer. And in that year, they charged for everything they did. And the place stood vacant and costs had to be amounted. Like, I don't understand how they work. I mean, they're just spending so much money.
I'm surprised that they did it that quickly.
Wow. That was
that you're talking about the government,
yeah.
A government agency. I'm shocked, Barry. I would have predicted 2 or 3 years.
Well, it just seemed the money was just running down. I mean, you've only got an infinite amount of money. Let's say you, in this case, one case, the apartment was only worth 300 and change. And it's a clock ticking backwards because you're eating at that equity at all times until you're down to almost nothing.
Well, you're looking at public servants. They don't know the word urgent.
But they know how to charge. They charge just like lawyers do for everything they do.
No, they're worse.
Well, let's get back into the wills themselves. I have a will. You did my will. Wow. I'm back on. You have to, Bob, you have to unmute yourself. We got muted.
Yeah, we got muted by the host. Sorry.
We got muted. I was just saying, if I had a will today, May the 26th, made, and you did that will, does that override and cancel my previous will?
The typical wording in a will says, I hereby revoke my previous wills. But if you don't have that wording in it, then you've got a nightmare. I haven't seen any cases like this, but there may have been some cases where if the previous will was not revoked, then there may be a conflict. If will 1 says I leave my estate to A, and will 2 says I leave my estate to B, and will 2 doesn't revoke will A, what happens?
Well, then that leads me, you would never do that though. As a lawyer preparing a will, you would never do that.
Paragraph 1 of every will that I've ever seen says I hereby revoke.
But that's the danger then of people using these will kits that they buy on the internet. Is that correct?
Will kits are wonderful things for lawyers who go to court over wills. I have seen so many people screw up their wills with will kits. It's just a disaster, and there's all kinds of reported court decisions of people who messed up their wills with using kits. So I strongly recommend not using a will kit.
Okay, I don't want to get into this, but just brief. I don't want to touch on the cost, but from a lawyer's point of view, they're not an expensive instrument for a lawyer to charge a client. I mean, they're not that expensive.
They're not expensive, and I regard it as insurance. Make sure everything is done properly.
So a husband and a wife, they own property together. Is it practical for both the husband and the wife to have a will separate?
Well, here's the problem. If a husband and wife have wills and they're not reciprocal, So the husband leaves everything to the wife and the wife leaves everything to the husband. But what happens if they both die together in a plane or a car? And the wills say, if my spouse doesn't survive me, it goes in different directions. Who dies first?
Right. Right.
So the reciprocal wills should be should match each other. Husband and wife wills should match each other.
So they should go to the same person, the same lawyer to draw the will,
Yes.
each will.
Yeah.
And I got to think that one out about two people having completely different things in their wills, including
So
from,
what the law says is, the law says in a case like that, it's instead of being deemed to be survivors, like joint tenants with right of survivorship, where it goes to the other, it's 50-50. So the husband's half goes to the people named in his will, and the wife's half goes to the beneficiaries named in her will, even if they don't match.
well, let's just stay there for a second. Okay, let's stay to beneficiaries for a minute. In my years in appraisal, I had a record. I think I had somebody in their mid 90s divorcing. That was my highest. That was somebody in their 90s. And usually I just did my job and everything else, but I was so curious. Instead of letting one of my staff go do it, I went to see the man myself to go do this one. And I said to him, because my curiosity was too much, why would you divorce in your 90s? And he said, because I don't want her to inherit anything. I'd rather settle it now, but I also don't want my daughter to inherit anything either. So can you eliminate, let's say you've got 3 kids, can you eliminate one of your kids? Because your kid, let's say, was just a bad kid, drugs, whatever, you just don't want that kid to have money.
As long as the beneficiary or potential beneficiary is not a dependent, somebody who has a right to claim against the deceased. As long as it's not a dependent, like a child or a spouse without income, they can be cut out.
You can cut somebody out of the will.
You can cut somebody else. You can cut somebody out, but in order to avoid the problem of the cut out beneficiary saying afterwards, my relative forgot about me, and it may have been an accidental, or it may have been under duress by the other beneficiaries not to leave anything to me. It's a good idea to say, I'm deliberately not leaving anything to beneficiary A.
You
Or
name the person.
you name them and say, I'm not leaving anything to my child A who was bad to me, or I leave $1 to so and so.
Okay.
So it shows that the testator or testatrix, the person who made the will, directed his or her mind to cutting out the potential beneficiary.
So I have a family member, lovely, lovely person, and they know that this person could not handle a large lump sum of money. And they were worried, and they doled out, they created a trust for them. And the people listening, they may be worried about the same thing. All of a sudden, somebody who's just a good heart person, they know within a year the money will be gone. How do you allow for that to, let's say, can you set up an annuity? Do you set up a monthly plan, dole them out money over a certain, like put them on an allowance of the estate? Can you do that?
Yes. So there's 2 scenarios. Number one is where the person is on an Ontario disability plan, and the other is where the person is either a spendthrift or has no children, and if that person inherits money, where's it going to go at the end of that person's lifetime?
Right.
So
Or
you set
just
up
irresponsible, Bob, or just can't handle money.
Yeah.
Not a spendthrift, just can't handle money.
What good is it to leaving money to a person who's going to inherit at age 70 or 80 or 90 and has no children, no next of kin? So the giver, the person who's making the will now, might want to say, well, I will leave in a trust all my money to my child, with the right to receive all the income and the right in the discretion of the trustee, who could be a trust company or a relative, to encroach on the money to encroach on the capital for the purposes of health care, for the purposes of medical care, and for the purposes of maybe housing or a car or a vacation. So you can restrict it to healthcare, or you can say, look, as long as that person can encroach on the capital to maintain the lifestyle that I had, but then you have to have a residual beneficiary. So you could say, after the death of we call it an annuitant, the person who is entitled to the income from the trust. After the death of that person, I direct that the trust be conveyed by my trustee to Baycrest.
So then you look at this and you look at, okay, let's look at this. Let's forget about the person receiving. Let's go to the person giving. I want to make a will. Now I'm fortunate. I've got, you are my lawyer, but my nephew is a lawyer, and he doesn't do wills, but he's my trustee because he's younger. That's another thing too. You should always
another thing. Yeah.
You get trust and name a second trustee as well, right? You should always have, if this one doesn't survive, you got another trustee. How do you choose the trustee? Like, could you turn around right now? And this, I really don't know the answer to this one. Could someone turn around, and it's no longer the word executor, estate trustee, could they appoint me as their estate trustee in the will without even asking me to do it? Or do I have to be, they could. What if I don't want to because I'm not capable of handling it? I just don't want to do it.
I had a client some years ago who liked the sound of the voice of somebody on the radio, of a female radio columnist. And she died of cancer very young. And I contacted the person at the radio station and I said, well, so-and-so, my client, has made you her executor. And she said, who? And I gave them the name, and she says, I've never heard of this person. She said, I don't want to do it. So she said, I'll sign whatever's necessary, but I'm going to renounce the right to be the executor. I don't want to do this. So my philosophy is, yes, always ask the executor, number one, if they will do it. The other criteria is, are they young enough to be the executor? Are they going to outlive you? And are they capable of doing it?
Yeah.
So a person might have two kids. One is a terrible spendthrift and couldn't keep two nickels together, and the other is wonderful with managing money. And the clients will say to me, well, how can I make one the executor and not the other?
Mm-hmm.
And my answer is, first of all, you're not going to be around to hear the flack when it happens. And secondly, I think they will understand. I think they will understand that they are being chosen and that the sibling is not being chosen based on their financial ability. And honesty, of course. You have to choose somebody who's going to treat the money with a sacred trust. So
I met too many in my career, Uncle Freds, who benefited greatly from being named to look after the money.
Yeah.
Quite a few. And of course, they end up in court cases. But, you know, it's interesting. The role of now the word executor is gone, correct? It's now a state trustee.
State trustee, but in a will, we always use both terms.
Okay. So I am appointed as an executor, and I'm an estate trustee. And there's people listening here today. And I've asked this when I teach classes. I've asked people to put their hands up. How many people in this room, and we've got 39, almost 40 people on this call. I'd say, how many people here have ever been an estate trustee? And a few hands will go up, sometimes more. And I always ask the same question. And how much did you charge to do that? And it's always that, it's stereotype. It's that dutiful daughter or daughter-in-law who gets stuck with it. And every stamp that goes on, every envelope she licks and sends out is a cost factor. And I keep explaining, you are entitled. You're not getting your full share of the estate if you're one of the heirs also, because you're spending money out of your pocket that you're afraid to charge your siblings back for. They're entitled to get paid, aren't they, Bob?
So the answer is yes, they're entitled to be paid. The typical remuneration is 5%. 5% of the capital in and capital out. It's capital. And the income expense, 2.5 of the income in and 2.5 of the income out. The problem is, and I had this happen to a client of mine, she said, when my cousin died, he made me the executor, and I got 5% of a very large estate, but my accountant tells me I have to pay income tax on it because it's earned income. So I always put a clause in the will which says, and I bequeath to my executor a sum equivalent to the amount of money they would have received as a state trustee compensation. And this money is in lieu of compensation on the understanding that they will not claim compensation. And it is a bequest. So I make it very clear. And then they don't have to pay tax on it.
So let's go through this for a minute for some of those that are on here that are going to end up either being estate trustees or they're going to appoint an estate trustee. There's been changes to the law. I mean, now, from what I know from my own experience, you need to have everything appraised, everything that's owned as an asset, that's potential capital gain, correct? The paintings on the wall, the collections, everything.
Well, the answer is you only have to have it appraised if somebody's going to challenge you.
Okay.
Okay, so if somebody leaves a coin collection to his kids in equal shares, let the kids worry about it. So I remember an estate where there was all kinds of wonderful furniture in the house and mahogany, just beautiful stuff. By the time we sent it to, I think it was Waddington's back in the 70s, and there was moving costs, appraisal costs, insurance costs, storage costs, and auctioneer's fees, there was almost nothing left for a house full of furniture.
Yeah.
So an appraisal is nice in theory, but so
well, I just had one with a stamp collector. No, he left no kids. He left everything to a friend, and he had a huge stamp collection. And he had to have it all appraised, and they had to go find an expert to appraise these stamps.
Well, if the entire estate's going to one beneficiary, you'd say to them, here's the stamp collection, we're putting it in at a nominal $100 or $1,000 for probate purposes, for paying the government's outrageous fees, but we're not going to get it. Why spend the money on an appraisal if they're going to get everything? Like, what's the difference if a car is worth $500 or $5,000 if it's going to the same person? Why pay for an appraisal? I'm a very practical person.
Well, I know that in my years in appraising, when I was an appraiser, we did an awful lot of appraisal work for capital, for death, for estates. Sometimes we had, of course, capital gains as well, because we had to go back to the V-Day, which is pretty well dried up now, because that was December 31st, 71. And of course, there's not a lot of people holding real estate before that today. But there are a fair amount of, but a lot of people are just, I find, are overwhelmed becoming an estate trustee. It's just a tremendous amount of work.
Well, that's where an estate trustee can seek assistance.
Right.
So an estate trustee doesn't actually have to go to a house and inspect it. So I was an estate trustee on a Hoarders house in Scarborough, and the beneficiaries were Americans. The two sons were Americans. They didn't want to have anything to do with it. And so they said, Bob, would you do it? And I said, sure, I'll do it. I didn't want to go into the house, so I got Barry to do it, and then he had somebody who was expert in cleaning out houses, and then there were a whole bunch of computers there, and we had to bring another expert in to look at the computers, which were old Commodores, I think. But
can I stop you? This is an aside. There was a brand new TR. It's the original Apple computer. It was in the original box, never taken out. Only thing done was the tape was taken off the box. It was a time capsule. We found it buried. That house, I took 33 visits. I logged all my visits, 33 visits. By the way, you said American. You cannot be an estate trustee unless you have to be in Canada. Am I correct?
No. So here's the story. Here's the story. The two sons were Americans.
Yeah.
You have to put up a bond through an insurance company to the court in an amount of double the value of the estate. And that bond continues and continues and continues until the estate is distributed, until you get releases from everybody, until you pay the taxes. Then you go back to the court and say, okay, we're finished, release the bond. So you just have to keep paying. And even now, sometimes if the beneficiaries are Americans, and I've had this, if the beneficiaries are Americans, and if they steal the money in the estate, they're stealing from themselves. So there's really no reason to put up a bond. So what I do is I make an application to the judge, and I've got a couple of these in now. I make an application to the estates court to say, I apply for dispensation with the requirement to provide a non-resident bond, because there's no reason to bond yourself to give yourself the money, because if you steal it, like, who cares? So in that case, if the proper affidavits are put in, the bond will be waived by a court.
So let me ask you this. People have to realize something. When there were once upon a time in our lifetime, there were probably 30, 40, maybe 50 trust companies around the province of Ontario, if not more. And almost all the trust companies have, quote, disappeared, but they haven't really. They've gone behind. For instance, Scotia owns what was National Trust. TD, people, I always say to my classes, why did they keep the name Canada Trust? Why did it become just TD? And therefore, there was a reason for the trust companies versus every one of the banks owns a trust company, correct? All the banks.
Yeah.
And the reason is because there's so much money to be made in the fees for being the trustee. Why would I, as a, quote, small guy, want to appoint one of the trust companies versus my own estate trustee? Isn't it going to be much more expensive to go, let's say, to RBC or to Scotia or whatever than, just getting...
So the answer is yes, but number one, the trust companies like the Bank of Nova Scotia Trust Company, those trust companies, they'll tell you what their fees are, but they are negotiable. So that's number one. Secondly, if your estate is going to go down to through a couple of generations before it's finally distributed, your estate trustee may not live that long. So take somebody who says, I leave my children a life interest in my estate, and then after their lifetimes, I leave it all to my grandchildren in equal shares. Well, who are you going to appoint? Your children are not going to be around after they die to give the money to the grandchildren. So you'll want somebody, some trust company. You'll want a trust company who has longevity and it was governed by the law to hold on to that money for 50, 75 years until the grandchildren or the great-grandchildren inherit the money.
I just ended up, I was asked to be an arbitrator recently on a land lease situation right on Yonge Street downtown. And it's a 100-year-old land lease, and it's been in the same family for over. You're right. I never even thought of that. It's 100 years since it's been. They've inherited this land lease.
So the reason you would have a trust company is if you don't have anybody you trust, if you don't have any relatives, or if the people you have aren't going to live. To pass on to your ultimate beneficiaries.
But isn't just playing devil's advocate for a minute? But it's going to eat up a lot of money. I mean, they charge, no offense, about the same money as one of the top law firms charges by the hour and that, don't they?
No, I think they charge a percentage.
Just a flat percentage, okay?
Yep.
Okay, plus property management fees and all that.
Oh yeah, but so what?
Okay.
So if they charge 2.5% of the capital receipts, 2.5% of the capital disbursements, 2.5% of the income receipts, 2.5% of the income disbursements, so what?
Okay. So
They're
here,
they're giving you the longevity and the trustworthiness. So you don't have to worry about money being stolen. Yeah, they may not be as efficient as your trusted advisor, but they're going to be there for 100 years.
I'm finding a few people I know that I work with, accountants, that are getting into the estate trustee field as well. They're certifying, they're getting certified as estate trustees. And I've worked with a few, and I find it quite interesting that they're actually not just the big trust companies, it's actually other people. There's individuals that are estate trustees, as a profession.
But if they live long enough, that's fine. I'm a state trustee in certain limited circumstances. And I've been appointed by clients to be a state trustee. But now I won't let anybody appoint me as an estate trustee, especially if they're younger than I am.
Well, that's a lot of people are younger than you are nowadays.
Well, 70 is the new 50, right?
That's correct. That's correct. Except for my knees don't believe that, but that's okay. Somebody asked a question as we're going. I see a few questions. Roughly, Bob, but no, I'm not putting you to the wall on this one. For a very simple will, and not just Bob Aaron's fee, what do you think somebody should be charging around town for a will?
Couple will or
Basic will, once individual will, and then a couple will. Without putting you
500.
on the spot. $500.
Okay, first of all, you need a will and 2 powers of attorney. You need a will, power of attorney for personal care, and a power of attorney for property.
Yeah.
Okay, so 3 documents, 500, 750, 1,000, and then double that for a couple.
Yeah, you got me a living will too, so I think that's.
Yeah, and a living will is the same as a power of attorney for personal care. Living will is theoretically an American term.
Oh, okay. So the other thing is too, here's somebody's asked a really good question that comes up, and I'm working on one of these right now. I got a real estate situation where somebody put in 3, in this case, they're saying about their 3 kids are executors. And I sold a house like this a few months ago. And what they didn't put in the will was what happens if the 3 don't get along and can't agree. The will was written in such a way, it was the 3 of them had to make unanimous decisions. And what it didn't go further to say is, but if they can't make a unanimous decision, who referees it? Isn't there has to be something there?
That's why we have lawyers in courts. You can't agree.
But let's avoid that. How would you set that up to start with? If the 3 parties, they have 3 siblings, they have 3 children, and the 3 children, they're all getting along well, but they just can't agree. How would you set that up that they could referee it without having to go to the courts?
Yeah, who gets my grandmother's samovar? And they all want the samovar, or they all want the Tom Thompson painting in the living room.
Yeah.
And you can't slice it into 3.
Well, you could once. You could.
Yeah. So you could say, I appoint child number A to be the estate trustee, but that child is to take into consideration the wishes and advice of child B and C. So that's one way to do it. Another way to do it is to say, I appoint A and B and C to be my estate trustees. But if they can't agree, then any 2 of them can make a decision. Or if they can't agree, they are to hire a mutual arbitrator who they all agree on. And if they can't agree, each of them names an arbitrator, and those arbitrators agree on somebody else. So you can put in a mechanism to provide for a disagreement.
And here's another question popping up. So what mom and dad, the condo in Florida, the one we know the best, will they need a separate will for their Florida property?
Okay, so the answer is I do not give, and I cannot give, and I'm not insured to give advice on American law. So or Greek law. So I've had a number of clients say, oh, we've got and we've got the land in the Philippines, or we've got the land in Florida, or we've got the Greece, Florida, Italy, the Philippines. Those are the biggies. Oh, I've also had England. So I say, you call, you get advice, you find out whether this will is valid in the Philippines or Italy or whatever. Some countries, for example, say, we don't care what the will says, it goes to the oldest child. So then they say to me, it doesn't matter what we put in the will, it goes according to the law of the country. So I say to them, get your own advice. And in the will, I say, this will extends to my property in Corfu or in Sardinia or whatever, to the extent that the law there allows it to apply.
Bob, you remember my assistant Ida?
Yep.
So she gets a call from the Croatian consul that her uncle passed away and she's the beneficiary, and could she come in to see them? She gets all excited, you know, she's inheriting. Next day, I see her, she comes in, she's got her faces down, everything. I says, how did it go? Are you rich? He died owing money. They want me to pay the taxes. So, you know, you never know. You never know. I think that
Barry, hi, it's Laura here. I'm just gonna, a couple of people emailed me questions. So I thought maybe I would just read the question now, and perhaps Bob could answer them while we're talking about this.
Can we wait towards the end, please?
Sure, that's fine.
Okay.
Lori, whenever you want.
Okay. What I was going to ask you is, what about, let's go into this. What about divorce? What about divorce? What happens? And a remarriage?
In terms of a will?
Yeah.
Okay, when you get married, you should do a new will. When you get divorced, you should do a new will. End of story.
And you don't. You just don't. What if somebody just doesn't? You know, they second marriage and they die right after. You know, their second marriage. Does the second marriage negate the first? Do they inherit? I mean, what happens?
A remarriage, a marriage after the date of the will, voids the will, but I understand, unless it says in the will that this will is made in contemplation of my marriage to so-and-so, then it's okay. But I understand the government is working on changing that law. So you got to get advice at the time you're making a will. A divorce, if you forget to take your spouse, your ex-spouse out of a will, tough.
Well, there's another thing that people don't understand, and they really don't understand this, is that we really don't have, I'm talking from real estate now. There's no such thing as common law in Ontario for real estate, is there?
No, it's all statutory.
Yeah, so just to explain this to people that are watching, people live together, and if they're not on title, if they're not married, and they're not on title, they're really going to get nothing at the end unless they can actually prove that they've put money into that property, correct?
Yes, or unless they're a dependent.
Yeah, okay.
If somebody is cut out of a will and would otherwise go on welfare, the courts would intervene and say, we're not going to allow you to cut this person out and go on the public dole. We're going to dip into the estate to make sure you're looked after because you were a dependent.
I'm sorry, I've studied this for so long and my mind just blanked. What do you call a handwritten will?
Okay, the word is holograph.
Holograph. Are they legal?
Okay, so the answer is somebody wrote in a question.
Yeah.
A holograph will is done is on a piece of paper entirely in the handwriting of the deceased.
Mm-hmm.
So it is valid and it doesn't have to be witnessed. Right now, I have a situation where a man typed up his own will on a computer, used the proper precedents, the wording was fine, everything was wonderful. The guy had been an accountant, he knew what he was doing. And then he had his son, the main beneficiary, witness the will with the son's girlfriend. And a witness cannot be a beneficiary. So theoretically, that will was void. So I've now applied to the court and say, look, we know the will is void, but the alternate beneficiary under the law of, we call it intestate succession, meaning the law where you don't have a will, the son's going to be the beneficiary anyway, so let's just probate the will that was improperly witnessed. So I'm waiting to hear from the court, because either way, with or without a will, the son's going to wind up with anything, with with everything.
What if there was no witness? Was that still valid? No witness.
If it's a holograph, it's valid. If it's a holograph with, if it's typed and with no witness, it is not valid.
So it should be in your own handwriting.
Entirely, no part of it can be typed or drawn up on a computer.
Okay, that's interesting. I never even thought about it typed in, because anybody could type a will, right? Okay, that makes sense.
You can get them online, and people who get them online will probably use an American precedent, and they'll have to, their estates are going to have to suffer.
Now I die. Can CRA come after my estate for back taxes and stuff?
Yeah, they're there first.
Okay.
I had some clients come in. They were two young middle-aged women, and they were very, very upset. And they came in, they were crying. They said they were getting dunning calls from their late sister's credit card companies.
Mm.
And the credit card companies were bothering them like crazy to pay off their late sister's credit cards.
Right.
And there was no assets. The sister had absolutely zero assets. So I said to them, when they call, hang up. When they write you letters, tear them up or send them back. But you don't have to pay the debts. You can't get blood from a stone. And the beneficiaries are not responsible to pay the debts from their own pocket if the estate assets are insufficient.
You mean to tell me that if I pass tomorrow, my kids have to pay off my MasterCard?
The estate has to pay off the
The
MasterCard.
estate what happens? And if they don't, they don't.
If the estate doesn't pay, then MasterCard can sue the estate, and they can sue the estate trustees. But if the estate is zero, then MasterCard can't get blood from a stone. And that's what I told these clients. I said, they should never have lent money to somebody like your sister who had no assets and no income. Now, that's their own problem. So
we're better off to spend it before we die. Everything.
I spoke to a client once, and he said, my goal is to spend my last dime on my last day.
I agree. I'm so of that school, Bob. I really am.
And I said, I said to him, tell me when your last day is, and then we can plan for the future.
I know, if only.
I also tell clients ask me, do I need a will? And I say to them, if you're not going to die, you don't need a will.
Well, you know, today I just did a seminar this morning on seniors, and one of the stats is that right now, as we speak, there are in excess of 10,000 people in Canada that are 100 years of age and older, and that figure is growing and growing and growing. And the reason that I believe it's happening is because Canada Revenue isn't finished with these people yet. So, by the way, condo fees, they do take precedent. I mean, you have to pay condo fees on an estate.
You don't pay condo fees, the condo is going to register a lien and sell it out from under them.
Right. So that'd be pretty stupid not to pay the condo fee.
Yeah, Barry, I want to go back for a minute to the situation of the Hoarders in Scarborough.
Please.
The Hoarders house. And the question was at the time, does the estate trustee have to do everything? And the answer is the estate trustee can hire as many experts, cleaning companies, real estate agents, stagers, and anybody necessary to carry out the job of the trustee. So even though I was the trustee of that house in Scarborough, that was the Hoarders house, I never went to see it because I had trusted advisors, you and your people, who took out 33 loads of garbage from the house. It was including the brand new sofa that was wrapped up in the Eaton's packaging.
Yeah, the thing, you know, it was interesting. I just did another Hoarders house in the West End recently, and it was so unusual because he was the neatest of all hoarders. Everything was piled up perfectly. He had a record collection that was phenomenal, all alphabetical, and everything was done right, but it was still a hoarder. It was just full of stuff. It took us 8 hours with 7 guys to clear it. Burial. what do you put in about that? Now here, this has always confused me. This confused me. You pass away and the funeral is quite quick, but they don't read the will right away. And then they realize after the will, oh, that wasn't their burial instructions. Would it not be advisable for anybody listening that if you have specific things you want specific to your burial, you let the family know in advance?
Absolutely. I had a client who came to me. I did her will, and she said in her will, I want to be cremated and I want my ashes to be sent back to the old country. When she died, she had been senile for a number of years. She couldn't give instructions, and she died. She was a ward of the province of Quebec. They were looking after her and paying everything. Eventually, they tracked me down. This is months and months later. And I said, I finally talked to the government of Quebec, and I said, what did you do for a funeral and disposition? They said, oh, we buried her in Montreal, a pauper's funeral. And I said, oops, because nobody knew, and she had no family, no family here. And it wasn't like we were gonna take her back and send her to the old country. So tell people what your final instructions are. And you're right, the will often does not, well, most of the time it doesn't get read before the funeral.
Yeah, yeah. I noticed in the movies or television, the Americans seem to, you could actually post the will. Your will is a public record in some states, I understand.
We have a will registry which nobody uses. The other thing I strongly recommend is either make they call it pre-need arrangements. So go to a funeral home and either arrange for it, so you have written instructions, or prepay it so that the beneficiaries don't have to dig out of pocket until the estate is liquidated.
My
So
kids keep talking about
many of my
something
clients do that.
My kids keep talking to me something about me and ice flow. I can't quite catch what they're saying, but what happens if you want to leave? In my case, my two granddaughters are underage. What if I want to leave them as beneficiaries and they're underage and they inherit, and what happens to the money then?
So there's two things. If you leave it to them and that's all you say, the money is going to the public guardian and trustee until they're 18.
And do they charge? Okay, let's just take.
Oh yeah, they charge, but
So
they invest it, but they charge. Okay, but so they charge. So what?
Okay, I'm just wondering. So what?
But your estate trustee is going to charge anyway. So what I say is to the clients, I ask two questions. Number one, who's going to hold the money until they're 18 or whatever age, 18, 25, 35. Sorry, that's my phone. I say, what happens? Who's going to look after the money, the parents or the government? And if it's the parents, then I let the parents put in. I put in a clause which says the parents can look after the money until the kids are 18, assuming you trust the parents. And then the next question is, if they get the money at 18, 21, 25, can you encroach on the capital of that money for education, for a car, for college, for medical care? And if they say no, then the kids get all the money. And if they say yes, then in the discretion of the parents, the money can be used to pay tuition or the summer trip to Europe or whatever. Depends, of course, on how much money there is.
Right.
So you have to talk about the right to encroach before the kids get the money and who's going to look after it. In the absence of anything in the will, the money goes directly to the government to look after until they're 18.
I have one more question before I ask Lori to jump back in with the other questions. My last question for you directly is, the family that I'm deceased. I've appointed an estate trustee, and my kids or my grandkids turn around and say, whoa, 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 we think he's doing a horrible job, either bad bookkeeping or we think they're stealing or whatever. How do you get rid of an estate trustee that's been named? How do you have to go to the court?
You have to go to court.
And it could take a while. I mean, the state could be depleted by then, though, right?
Yeah. Let me answer a question that was in the chat function. Somebody said, does it make sense to transfer a cottage to a child while you're alive to avoid the 1.5% probate fee? And the answer is, If you give a child an interest in a property, A, you're going to trigger a capital gain,
Mhm.
which can be very expensive. And B, there may come a time when you need the money and where you need to sell the property because you want the money for your old age or to buy that place in Florida or whatever. And if the kids say, sorry, mom, we're not going to sell the property because we have we have a third interest in it and we're not giving it to you. And there have been reported decisions about that. So does it make sense? Maybe, and maybe not.
Another point on that, you also may be depriving that child or that person of their right to be a first-time buyer and get the benefits of being a first-time buyer, because they're a real estate owner.
So you can gift somebody asked, you can gift a property for natural love and affection. But if it is a taxable capital asset, the government's going to say, sorry, you may not have received money from your kid when you gave them a third of your $2 million cottage, but we're going to assess that as a disposition at fair market value, and you're going to pay capital gains on it.
Lori, do you want to, you have other questions? Do you want to jump in as we're coming to the end here? Lori Banks, we're there. Yes. Lori.
Hi. All right. We have two questions. Put my eyes on. Okay. One question is, I have a mandate written by a notary from when I lived in Montreal. Do I have to consult with a lawyer and have it changed? The person's now living in Toronto. Also, do I need to make a new will? And I think this is an important question, you know, especially here at 2 Neptune. We have people that are moving from out of province, you know, to our building. If a will was drawn up in another province, does it need to be revised here in Ontario?
Well, I guess it depends where the person is a resident of and whether where your assets are. There's no point in having a Quebec will if all your assets are in Ontario. There's no point in having an Ontario will if all your assets are in Quebec. So I tell people, call the Montreal notary or the lawyer in Quebec or the lawyer in Rome and find out if that will is valid for the assets there. And I'll tell you whether your will is valid for the assets here in Ontario. But it's really a question of foreign jurisdiction and the laws of that jurisdiction.
Okay, thank you. And then the second question I received by email was my mother, who is on the cusp of a dementia diagnosis, has structured her will that her estate has an uneven distribution between my sister, my brother, and I. So it's 20%, 40%, 40%. My sister, with whom my brother and I are estranged, will almost certainly contest the will and has a better financial situation than we do. What are the options?
Ooh, wouldn't you like that question, Bob?
Hire a good lawyer.
That's right. There is no better answer.
I think the mother knew that. There used to be clauses which said if anybody contests my will, they are cut out. Those clauses are kind of they're frowned on now, and they may not be enforceable. But I guess the thing is to make sure the will says, I am deliberately, you make an explanation. I am deliberately leaving daughter number 3 a lower percentage because we are estranged. She hasn't talked to me. She doesn't need the money. Put it all in there so that if it ever goes to court, it's going to be quite clear that this was deliberate. It was made of her own free will and desire, and that there was no undue influence. And then the lawyer who prepares the will makes a docket that I discussed it with the person who wrote the will. I got all the following information. I made notes. I confirmed to myself that there was no undue influence. In other words, the lawyer who makes the will should have notes, extensive notes, why this happened. So if it ever goes to court, it's evident. The lawyer's notes are evidence that there was no undue influence, that the person was of sound mind and cut out or reduced the share of that daughter accordingly.
You know, Bob, just as we're wrapping up, I think I should get into this question. Somebody listening today says, you know, I think it's time I better redo my will, or I want to update, or I want to create a will. I don't have a will. Before they come to you or any their lawyer of choice, and you are my lawyer of choice, what should they do? What homework should they have to walk in the door? What should they have written out and put together?
So I have a questionnaire and I send it out, and it as preparation, and it forces the people to say, oh, it forces the people, first of all, to list the assets. And when they do that, it's question, you have to list everything. And it forces people to think, oh my God, I forgot about that account at so-and-so or TD or whatever. So at least you have a list and you have it frozen in time, a list of assets. And then we can deal with them. And then I say, oh, this RESP or this RRSP, this may have a named beneficiary, so we can't put it in the will because it goes automatically, life insurance policy, for example. So first we deal with the assets, and then the next part of it is, who do I want to be my executor? And then who do I want, oh, my substitute executor and the substitute. And then we say, and who are going to be the beneficiaries? And what if those beneficiaries die first? And what if the second beneficiary, the alternates, die first? And then we go through all this, and then I meet with the clients on Zoom and we discuss it.
Okay, so we're good, Lori?
All right.
It's good.
Well, we have one. Let's answer one last question in the chat. Barry, do you want to read that out to?
Yeah, it
to
says
Bob,
I have left, let's say, $10,000 to each of my 6 grandchildren. So there's $60,000, $10,000 each. And my husband does exactly the same. If I die first, my husband inherits all from me. Do our grandchildren not get any money from me? Or do they wait until my husband's estate is settled when he dies?
So the answer to that is, I would ask the client, do you want your grandchildren to get the money off the top or off the bottom? If it's off the top, then the grandchildren get the money before the husband gets the rest of the estate. And if it's off the bottom, then the husband gets the estate first and then the grandchildren get the money. So it's just a matter of what the person wants. Do the grandchildren get 10,000 from each grandparent, or do they only get 10,000 from the survivor?
Well, it's interesting.
That has to be carefully drawn.
Sorry, it comes back to what I just said about 10,000 people in Canada are 100 years old or more. People didn't realize how long some people are going to live when they plan. They didn't expect that. People need money to live. People are living longer and spending more to get there. So, Lori,
well, I had to thank you. I was just going to say, I want to thank you both today for giving us these words of wisdom. You know, I'm sure that from our participants, there were a lot of golden nuggets that were taken away from this, and certainly on my part. So thank you for that, both Bob Aaron and Barry Lebow, for being here today. I want to thank all of our participants today for the great questions, and hope you can join us for our next webinar, which is going to be next Wednesday, June 2nd, which is entitled Happiness is a Choice, which is presented by Susie Kalman, the owner and founder of the Gemini Group. And we hope to see you then. In the meantime, be well and have a wonderful day. Thanks, everyone.
Thanks,
Bye-bye.
Lori. Thanks, Bob. Bob, thank you
Thanks,
very,
everybody.
very much. Bye-bye. Thank you, folks.
Thank you.
Bye-bye.
Bye-bye.